series. Now we will turn the time over to our Mr. Nguyen, the senior partner of Dzungsrt, to have some words to kick off our webinar series.
Thank you, Trang. Good afternoon, good evening, good morning, whenever you are in the world. Welcome to Dzungsrt and Associate 2021 Arbitration Series International Arbitration Strategy and Participant Tip. We are deeply honored that Mr. Kevin Kim, founding partner of Peter and Kim, is here with us today for the very first webinar of the series. I also would like to thank Vietnam International Arbitration Center, VIAC, and innocent law firm including Peter and Kim, Heber Smith Freeing, Steve Brown, Kingwood, Madison, Information, YNK, Clanco, Queen Marian, and C7 consultant for the strong support for this event. And by the presence of participation of so many other colleagues in the international commercial arbitration field who will be present in the coming webinar of this series. Thank you everyone for joining us. So far, we have more than 150 participants from Vietnam and other 12 countries from all over the world, in which 50 registrants come from local and international law firms, 40 registrants are law lecturers, researchers, and law students from all major law schools in the country. More than 40 are in-house counsel of the local and FBI community. There will likely be many other registered in the coming day. Thank you for the time, taking the time and the effort to attend virtually despite the time zone difference. Throughout this webinar series, we benefit from a wide range of speakers, including the reputable professor in the law, the leading practitioner from the best arbitration practice group, and the expert you may want to engage as witness in your case. They are leading practitioners and professors from all over the world, all with very busy schedule, but they always have time for us. Along with the speaker presentation, we benefit from the panel discussion, where we see how each other of the issue is dealt with in the real life from both international and local practice, especially under the current impact of the COVID-19 pandemic. I wish everyone a rewarding and enjoyable day and would benefit from all our 7 webinars. Without further ado, I will kick off the webinar series with the first topic on jurisdictional challenge. And I now pass on to Ms. Nguyen Trang, who actually designed this series of webinar and who will moderate the webinar today. Thank you.
Yes, thank you, Mr. Dung, for your welcoming speech. Now, with further ado, I will start our webinar today regarding jurisdictional challenges, why and why not. It is one of the most important objectives for business users to have their dispute resolved in a final and binding manner in as quick and cheap a manner as possible. Arbitration has been the choice of so many disputes, small scale to large scale, simple to complex. The power of the tribunal to determine dispute is dependent upon the existence of a valid arbitration agreement. Challenges to the tribunal's jurisdiction are a common feature of arbitration. The discussion today will focus on how the jurisdictional issues arise and consideration of options open to the parties to the arbitration. Regarding the topic, we have Mr. Kevin Kim, the senior partner at Peter and Kim, a leading international arbitration firm with offices in Geneva, Seoul, Bern, Sydney, and Singapore. Kevin is based in Seoul and was previously a senior partner at Beck Kim and Lee, where he worked for the past 3 decades in various roles, including as the co-founder and head of the international arbitration practice and the head of the domestic and international disputes group. Mr. Kim has more than 30 years experience acting as the counsel, presiding arbitrators, co-arbitrator or sole arbitrator in more than 300 cases of international arbitration under various arbitration rules. Presently, he is involved in several arbitration, both investment and commercial. Among other positions that he holds, Kevin is also an advisory board member of the International Council of Commercial Arbitration, ICCA, and the chairman of the KCAB. International Arbitration Committee. With regard to other panelists, we have Mr. Chen Ha-hen, who is the litigation partner in Dzungsrt and Associates. She often represents clients in enforcement of the foreign arbitral awards in Vietnam before various courts at provincial and high court level. The Legal 500 Asia Pacific in its publication describes her as talented young lawyers, and therefore she can share with us a lot of experience regarding the jurisdictional challenge in Vietnam. And we also have Ms. Minh Ha, who is the commercial and maritime partners in Dzungsrt and Associates. Her practice focus on commercial and maritime arbitration. Ms. Minh Ha involved in a number of both domestic and international arbitration, not only at Vietnam International Arbitration Center, but also at foreign institutional institutions such as ICC, SIC, SCMA. The range of her arbitration experience extends to commodities, construction, infrastructure, energy, maritime, and insurance. She has also assisted foreign clients in recognition and enforcement of many foreign institutional and ad hoc arbitral awards in Vietnam. So we hope that with the three experts, we will have a successful webinar, and our speaker will also share a comparative view of the international practice and the practice in Vietnam. So to begin, we would like to invite Mr. Kim to deliver a keynote speech on common challenges and consideration when raising challenges. Mr. Kim, the floor is yours.
Thank you very much. Thank you for your kind introduction. And thank you for organizing this wonderful webinar. I see that all the topic is really fascinating. I got the honor to cover the first topic. I feel big responsibility just to make the whole seminar have good start. You know, everybody's entertaining the whole process. Maybe I can share some slide I have. Can you see my slide?
Yes, we can see it now.
Okay. All right. So I try to keep the contents short and practical and straightforward. So the first issue I want to address is the party autonomy. The principle of party autonomy sets boundary for arbitral tribunal jurisdiction. Arbitral tribunal can only exercise its jurisdiction over a matter to the extent that parties have agreed between themselves. Of course, further boundaries are set by the law of the state where the arbitration tribunal is seated, but the final details are often decided by the parties. Therefore, I'm starting with this slide to emphasize the importance of party autonomy in determining the limitation to the jurisdiction of arbitral tribunal. A party will challenge jurisdiction of a tribunal when it has reason to believe the tribunal is assuming the power beyond its mandate. The aim of this, the contesting parties bar the arbitral tribunal from exercising jurisdiction over the matter. So in other situation, it could also be challenged the enforcement award at the later stage. Okay, and there are basically four broad categories of jurisdictional challenges. They can based on first the validity of arbitration agreement and the constitution of arbitral tribunal, was it properly constituted? And three, the scope of arbitration agreements that parties agreed between themselves. And finally, the power that has been vested to arbitrary tribunal. So let's now talk about first category, i.e. The validity of arbitration agreement. A jurisdictional issue concerning the validity of arbitration agreement could include the questions as to number one, validity of arbitration agreement itself. Example, if it was properly executed. And number two, it could also relate it to any issue with the underlying contract that contains arbitration agreements. That we have a separability issue. So the theory of separability in arbitration means that arbitration agreements are separable from underlying contract. So even if the overall contract falls flat, the arbitration agreement can be separated to give it life, so that arbitration procedure move ahead to determine the right and liability of the parties. Okay, the second category of category related to constitution of the tribunal, jurisdictional issue related to the constitution of the tribunal may concern whether the agreed or statutory default, the procedural were followed for appointment of arbitrators, and whether the respondent was effectively served with notice of commencement of the arbitration or notice of appointment of the tribunal. And also whether the arbitrators are precluded by arbitration agreements and or by arbitration rules or laws of the seat from taking the appointment. And third category is that the scope of arbitration agreement. So jurisdictional question to scope of arbitration agreements may concern, number one, the identity of parties to arbitration agreements and to the arbitration. Number two, the arbitration agreement itself or dispute it does or does not cover. Third, whether the subject matter of the dispute can be arbitrated. So we call the arbitrability. And the fourth, time limit for commencing arbitration. And fifth, whether the parties have complied with any condition precedent to commencing arbitration. The fourth and final broad category is that of arbitration tribunal's power. So jurisdictional challenge relating to arbitrator's power may concern, number one, the tribunal's ability to award certain remedies. Number two, the tribunal's ability to render interim or partial award. Third, number three, the tribunal's power to award cost and or interest. Now that we have determined four broad categories on the basis of which the jurisdictional arbitral tribunal can be challenged, the question arises as to how does one raise jurisdictional challenge? Under most legal systems, a tribunal has a power to rule on its own jurisdiction. The right to challenge the tribunal's substantive jurisdiction may be lost if it is not taken at the outset of the arbitration. So therefore, any challenge to tribunal's substantive jurisdiction should be raised at the earliest possible opportunity in proceedings. However, a challenge that tribunal has exceeded its jurisdiction may be raised during the course of arbitration. In many situations where arbitrary tribunal has decided positively on its jurisdiction, the contesting party may still have a second chance in challenging an arbitral tribunal jurisdiction after arbitral word has been mended. This can be done in the several ways. First, by commencing a specific challenge to the word. And second, resisting enforcement on the ground of lack of arbitral jurisdiction. And in certain circumstances, non-participant may also challenge the word if it affects their right. This is a very brief overview of the jurisdictional challenge, and I hope we will have chance to discuss a few more aspects of during the panel discussion and in the Q&A. Maybe I can stop sharing the screen. And I hope we have more discussion on the question and answer Q&A session.
Yes.
Thank you.
Thank you, Mr. Kim. So we now have a very overview of how common challenges that one parties often raise during the arbitration, like related to the arbitration agreement, the constitution of the arbitral tribunal, the scope of the arbitration agreement, and the tribunal's power to render some kind of measure or what. So, but this is the theory. And how about the practice? So we want to have the panelist discussion to have more insights on the practice of the challenges that parties often raise during the arbitral proceedings. Mr. Kim provided us a lot of information about international arbitration, but what about in Vietnam? What are the most common grounds based on which the party challenge the jurisdiction of the arbitral tribunal that we often see in Vietnamese court? Maybe our Ms. Hun could share some experience about this.
Yeah, thank you, Trang. And first of all, I would like to hello everybody for joining with us in the webinar today. And thank you very much, Kevin, for your sharing about the practice of international arbitration regarding the jurisdictional challenges. And in Vietnam, the jurisdictional challenges are quite diversified. But from our research and our experience in handling the case regarding the setting aside procedure and enforcement procedure of the foreign arbitral award in local courts, we see that there are 4 categories that the parties often use to challenge the jurisdictional arbitration. First is the challenge on the validity of the arbitration. Validity is on the existence, challenge on the existence of the arbitration agreement. And from our experience, the most common challenge is due to lack of the signature or confirmation of either party in the arbitration agreement. I remember that 3 years ago, the Hanoi court issued a decision to resolve a request to set aside an arbitral award resolved by VAC. And in this case, the claimant filed a statement of claim against 6 defendants to request payment of a debt. And the debt is based on a debt confirmation letter. And but notably, this debt confirmation letter had an arbitration clause, and this confirmation letter was already signed by the defendant and without the signature or confirmation of the claimant. And in such case, I remember the tribunal finally accepted the claims of the claimant and requested the defendants to pay the debt to the claimant. But after that, the defendants requested the local court to set aside the award with the key argument that the arbitral tribunal did not have jurisdiction because they argue that this debt confirmation did not have signature of the claimant. And then the court accepted such argument of the defendants and ruled that this debt confirmation letter did not constitute an agreement between the parties, and the arbitral tribunal did not have jurisdiction to hear the case. This is the first categories of challenge of the jurisdiction of arbitral tribunal, which we have matched in some case we handle. And the second is they often challenge on the validity of arbitration agreement. Especially, they often argue that the person who represented for each party do not have the signatory capacity. For example, they was not the legal representative, they was not duly authorized by the legal representative to sign the arbitration agreement. And this is a very common ground that the party usually to use the challenge of the validity of arbitration agreement, and then the jurisdiction of the arbitral tribunal. And especially, we often see that in the recognition and enforcement procedure, which I have handled many cases, and the local party often based on such argument to request the court to reject the recognition and enforcement of the foreign arbitral award. And the third category is the local party often challenge that the dispute could not be resolved by arbitration, or we normally call it is non-arbitrability. In practice, we often use that the jurisdictional challenge on the arbitrability may arise in some dispute between the individuals and dispute on the real estate or on labor. And I remember that 3 years ago, there was a very famous case resolved by VIAC relating to a non-compete agreement between a global e-commerce company and such company as in the role as an employer with in a dispute with an individual as their employee. And in such case, the company filed a claim against their employee because he has breached the non-compete agreement after stop working for the company. And the arbitral tribunal then issued an award to accept requests of the claimant. However, after that, the award has been set aside by the local court as per the request of the employee, with the reason that this is the labor relationship, so it should be settled by the court rather than by arbitration. Yeah, and the last one is we often see that the party often challenge the jurisdiction of the tribunal based on they argue that the tribunal act beyond the scope of arbitration agreement. On this matter, we know a case in which the court issued a decision to set aside an arbitral award because they apply that the arbitral tribunal act beyond the scope of arbitration agreement. And in such case, the claimant initiated the arbitration to request the defendant to pay compensation. And the defendant also submitted a counterclaim against the claimant. And then in the arbitral award, the tribunal concluded that both parties had obligation to each other, and the tribunal offset two amounts and ruled that the defendant had to pay the balance for the claimant. However, after that, the defendant requested the local court to set aside such award with the reason that the settlement agreement having the arbitration clause only provided the obligation of compensation of the claimant to the defendant, but not mention the compensation obligation from the defendant to claimant. So the court finally accepted the request to set aside of the award, and because they concluded that the tribunal has acted beyond its jurisdiction with respect to the claim of the claimant. Yeah, and that are some category or grounds relating to the jurisdictional challenges, which I would like to share with you for your having the general view on this matter in Vietnam. And thank you so much for your listening. Yeah.
Yes, thank you, Ms. Hun, because you not only just stating the common challenges that one party is often raised, but you also mentioned the practice in Vietnam on the court's opinion on such several example cases that you mentioned in both Hanoi and Saigon. We all understand that the second question that I want the panel to discuss is, we all know that based on the competence principle, the tribunal has the power to rule on its own jurisdiction. So in case one party raises a jurisdictional challenge, what are the common factors to be considered by the arbitral tribunal to deal with such challenges? Mr. Kim, maybe we hope that you can share with us from the view of international arbitration first.
Okay, thank you. It really depends what challenges you raised. The tribunal gonna see, whether the parties argue on any particular point. So, for example, in certain countries, a certain form is required, or certain. In case of, I understand that UAE, there is some unique requirement in the entering into arbitration agreement. As the company, you need the special approval by the board of directors. So that if somebody challenged that because there is no board of directors resolution, the arbitration agreement is invalid, then the tribunal naturally focusing on that issue. But normally, as you know, other than the written requirement, there is no specific requirement for the form of the arbitration agreement. So their issue is whether or not parties have actual intention to enter into arbitration agreement. And practically, arbitration agreements normally matters when a party actually signed the arbitration agreement, but the party signed on behalf of other company, or there is some related company. I have a case where the parties negotiate for 2 years, and just before entering into the contract, the party just proposed that, oh, we have some tax implications, so we want to have our we just have established a paper company in different country, so that paper company will enter into the contract. So that the other side say, okay, you can do that as long as you guarantee every part of agreement. So another company, principal company, say yes, we agree. Then it was guarantee agreement, which is signed at the same documents in the contract. And then when parties have dispute, and the parent company just say, okay, we guaranteed the obligation of this paper company, but we never agreed to arbitration agreement. So that issue of separability, so that is always cause the various issues. And we have many other occasions where the affiliate or the actual person they negotiate a bit different from the actual party to the arbitration. And there is some situation where the company was spin off or they merged with other company, and the company become bankrupt. Then we have issue that whether the receiver of the company should be the party to the arbitration. That causes a quite complicated issue. How you deal with that? Every country have different system of bankruptcy law, and whether or not the company was become under a liquidation process, the arbitration agreement is still valid. So the arbitral tribunal will review the various the aspect of our arbitration agreement and the jurisdiction, but the practice in international arbitration is the arbitral tribunal hardly accept the arguments that non-signatory is a party to the arbitration. So I haven't seen. I only remember only one case. In France, there is they create a theory, the so-called the group company theory, in one single case. But even after that, I haven't seen any case where the tribunal, at least the international arbitration tribunal, applied so-called the group company theory or some piercing corporate bail theory to acknowledge the jurisdiction over non-signatory party. Almost all occasions, the tribunal dismissed and denied jurisdiction over non-signatory of arbitration agreement. But in case of scope of arbitration, it's a more complicated one. So whether or not the tribunal have authority to decide over a particular matter, if there is any related contract, related issues, how much you can decide on the issue, that is more complicated one. Again, that is also related to which governing law should apply. So that is more oftenly argued, and then on that particular issue, the tribunal have different views and interpretations. So I would say the key thing is what parties intended in a contract. But most arbitration agreements, as you know, there's a very strong practice. Just say parties agreed very broad arbitration agreement. So normally just say any dispute arising out of or in connection with the contract. So that means that in almost everything. So we have a case where a party filed an arbitration against the other party for wrongful attachment in a local court, but the claim is arising from arbitration agreements. So the other party say, oh, the tribunal have no jurisdiction because it's not really related to the contract. But it's still arguable that as long as the claim is arising out of the contract or in connection with the contract, generally the tribunal and the court have a tendency to interpret the scope of arbitration as big as possible. So that is a normal practice. Maybe I can stop here and hear what is the practice in the Vietnam.
Yes, Ms. Han or Ms. Ha, can you share anything about this matter from Vietnam perspective?
Could you say?
From Vietnam perspective, the arbitral tribunal, I would share something from the viewpoint of the council, and from Vietnam practice, we usually rely on firstly on the arbitration agreement. It is, as all of you already know, it is the most important document for the basic for an arbitration. And also we consider other documents like the contracts and relevant documents of the deal, because sometimes the arbitration documents does not lies in the particular contract, but it refers to the bundle of documents, and furthermore, I also handle some insurance arbitrations where the where there are a numbers of documents, and in these documents there are different dispute resolution clause. Not all of them refers to arbitration, because, as you know, the in insurance contracts, the parties may endorse some international policy which already includes the arbitration clause, but when they modify the contract, they does not really cares about the dispute resolution clause, so they they refers the dispute to the court, but in the endorsement of the insurance policy, there's still a dispute resolution clause referred to arbitration, and then it comes to a question of which dispute resolution clause would prevail, and if the when we bring the dispute to the arbitration, so the jurisdiction of the arbitral tribunal also raised in that issue. And furthermore, we share the view with Mr. Kim that when it comes to the scope of the arbitration agreements, it becomes more complicated, because generally the arbitration agreement is very short, and it cannot if it is as simple as it covers all disputes arising from the contract, then it would be much easy. But in some particular case, the arbitration is not that easy. It so for example, if the specific some dispute which may be subject to arbitration, and some dispute would subject to other competent authorities. But for example, I list the dispute resolution clause in some charter party or the bill leading. It divide the jurisdiction will depends on the value of the claims. If the claim is more than, for example, 50,000 United States dollars, it will be subject to LMAA, and if it's smaller than that amount, it would be subject to other institutional arbitration, or and sometimes it is difficult to exactly determine the claim amount from the beginning of the arbitration agreement, from the beginning of the arbitration. And sometimes even when the arbitral proceeding already begins, the claim amount also varies. So it's now also raised the jurisdiction question, not only from the beginning of the arbitration, but also in later stage. And that's some of my experience in some specific dispute type, like insurance or maritime, which I usually handle.
Yes, Thanks, Han. Actually, when Mr. Kim saying about the non-signatory party, I remember two cases that we used to involve, and there are very different views between Hanoi Court and Ho Chi Minh Court in that matter. In the first case, the representative director of one party signed the contract, but when it comes to enforcement stage, that local parties raised a challenge that, well, our representative director could only sign the contract under $1 million. And because the contract value is higher than that, so the contract is invalid, and as well as the arbitration agreement therein is also invalid. And the Hanoi Court accepted such allegation from the local party. But in another case in Ho Chi Minh City, in such case, the contract does not have the signature of the local party. It's blank, totally blank, no seal, no signature. But because in fact, parties perform the contract already. And so the tribunal and the courts, based on the exchange document between parties, and decide that, well, in this case, we do have a contract which is made by the conduct of the parties, by the subsequent conduct of the party. And therefore, even though if you look only at the contract, there's made no signature, there's made no agreement. But if we look in the whole, all of the documents in the whole, then we can set up an arbitration, a valid arbitration agreement. And in such case, the court in Ho Chi Minh City recognized such arbitral awards, which is issued by ICA, the International Court Association. So it's very, I think that in fact, we can see a lot of very different views between local courts, even from the north to the south, and also between Korean or Singapore court to Vietnamese court as well. Now we turn to the third question, which may be closely related to our topic today, is why and why not we should or should not raise the jurisdictional challenges. We all understand that in some cases, or under the rules of the law, there are deadline, or we would say the time to raise the jurisdictional challenge. So in case one party fails to do so, what if the one party raised the late challenges? Then what are the consequences? And whether they could be deemed to waive a right to object. So the panelists, maybe Ms. Hun or Ms. Ha could share with us first, and then Ms. Kim can step in to cover all other aspects as well.
Yeah, I would like to share some my experience in VIC, and I would look forward to hearing from Mr. Kim from the perspective of the arbitrators. Under the law on commercial arbitration of Vietnam, and as well as the VIC rules, you see expressly requires that any jurisdictional challenge must be raised in the statement of defense, and therefore we can understand that the deadline for submission of the jurisdictional challenge is the same as the deadline for submission of the statement of defense. That can be interpreted that if a challenge is not raised in the statement of defense, and this can consider as a waiver of right to object, and that party cannot raise that challenge at the later stage. It is and also we note now that the VIAC rules Article 9.1 clearly states that where the respondent fails to raise the challenge against the arbitral tribunal jurisdictions, is still deemed to have lost its right to raise objection thereto. In practice, there are some we saw many cases, both of the Hanoi court and the Ho Chi Minh City court, when the court recognized that the failure to raise timely jurisdictional challenge can be considered as a waiver of the right to object. For example, a case of the court of Hanoi, the Hanoi court rules that because the defendant did not state that the dispute fell out of the jurisdiction of the arbitral tribunal in its statement of defense, then it's waiver the right to object to the jurisdiction of the arbitral tribunal. But in practice, there are some cases where the jurisdictional matter can only be comes to the awareness of the parties when after the party already submit the statement of defense, and then we still raise that challenge, we wonder how the arbitral tribunal would deal with such a late challenge in practice, and then I would like to hear from Mr. Kim on how such a situation would be dealt by the arbitral tribunal.
Okay, may I answer?
Yeah.
Yeah. Okay. Yeah, you're right. You know, in the arbitration, when you file the answer, you have to before you answer on the merit, you have to make the objection. The same as the court practice. You know, once you state your case, then you have no opportunity to challenge your jurisdiction in a court. The same in arbitration, and then arbitration in act. Most arbitration act in the various jurisdictions have the clause that once party just participate arbitration without making objection, and it's be deemed to be agree a jurisdiction of arbitration agreement. But it also depending upon which rule apply. For example, in case of ICC arbitration, there is a terms of reference. The documents called terms of reference will be executed. So as long as you present your jurisdictional challenge until the terms of reference is finalized, ICC will accept that such a jurisdiction challenge, even though you did not put that the jurisdiction objection in answer, but still, when you try to finalize the terms of reference, they say, oh, actually, we have a jurisdiction challenge. That is acceptable. But once you sign the terms of reference, because terms of reference is kind of agreement between the tribunal and parties, then you have no way to challenge it. Even without any arbitration act clause, any other things, because this is separate documents to finalize the parties' agreement to the arbitration. So that is why the ICC required terms of reference in order to avoid any dispute in the future. So once you sign the contract, it's a separate contract and the more specific contract on that particular dispute. But other arbitrations under arbitration rules other than ICC arbitration, there's no such a document called terms of reference. There's a procedure order number 1 that covers various matters, but procedure order number 1 is not, it's just the order, it's not just parties agreement. So you always have a possibility to challenge the tribunal's challenge. But as I told you, in case of the arbitration agreement itself, unless you challenge at the beginning, the tribunal will treat that your participation without raising challenge or the reserve your right will be deemed to be agreement to arbitrate. But in case of the scope of arbitration or the tribunal's power to decide on particular matter, you can challenge it, in the course of arbitration. No particular time limit on the issue. Although there is always the issue that if the objection is raised too late and knowing the fact, you just proceed. Again, you have issue whether that'll be waived or not. But in case of arbitrability, it's not something you can waive. I mean, it's a matter of law. Whether or not you argue at the particular aspect. For example, you are not allowed to arbitrate or divorce itself. You can decide on the compensation of the result of divorce, but not divorce itself. Or the patent dispute, you can argue on the ownership of a patent or any right under the patent, but registration of patent itself, you have no way to arbitrate. So that is something it doesn't matter whether you agree or not to agree. You can argue that arbitrability issue at any time. But arbitration agreement itself, because the only requirement is that arbitration agreement should be in writing. And then there's another provision in arbitration. For example, in Untitled model law, allow the parties participate in the arbitration without raising of the objection. They'll be treated as arbitration agreement. So that with that particular provision, in most jurisdictions, it will be treated as admission or waiver of the objection and arbitration agreement.
Following Mr. Kim sharings on the terms of reference of ICC, I remember a case of Vietnamese court where the award debtor submitted that because the person representing the debtor in the arbitral proceeding who signed the TOR did not have the authorities to do so, and then they held that the arbitral tribunal did not have the jurisdiction, and they challenged the validity of the term of reference. And in such a case, the Vietnamese court accepted that argument. And they consider that the terms of reference is prolonged of the arbitration agreement, since the party signing that document does not have the authority to sign. Then the arbitral tribunal does not have the jurisdiction on that case.
Yes, that is a very interesting case, but I remember that is long ago. I hope that now the court will have a different view, which is more supportive to the arbitration, because actually in such case, the court said that the TOR form an arbitration agreement. So it's a new arbitration agreement which may prevail the original agreement in the contract, and therefore because the person signed the TOR did not have authority to do so. Parties does not have arbitration agreement, and the tribunal award should be rejected to enforce in Vietnam. And in such case, the court accepted such agreement. So it's very risky when you deal with some opposing parties. So please check the authority, the POA, to make sure that they have authority to sign the TOR or any documents during the arbitral proceedings. And it's also remind me of some cases where the local parties or any kind of parties, they did not participate in the arbitral proceeding. So it's kind of default award. And even though they were duly served on the arbitral documents. And then at later stage in the enforcement proceeding, they raised the judicial challenge based on the ground that there's no arbitration agreement, or the person who signed the arbitration agreement does not have capacity to do so. And because they did not participate in the arbitral proceeding, the court seems to assume that they have not been considered as waiver of right to object, because they did not have a chance to do so during the arbitral proceeding. That's what the court, the Vietnamese court, some Vietnamese courts say so. So what do you think about it, Mr. Kim?
In the course of arbitration procedure, you're supposed to have the representative, right, or the counsel. And for example, in case of terms of reference, in many cases, the counsel signed on behalf of the parties. Or sometimes party representative sign on the terms of reference in front of or with the participation of the counsel. And so in case of that, you mentioned about that case and terms of reference signed and denied. I think the most jurisdiction, it's quite difficult to argue that, the person has no authority. Basically, that means that the counsel have no authority to represent. That would look very, very bad, from if they at the local court just denied the validity of the terms of reference, unless you have a special circumstances where that the parties never appointed the counsel, never authorized the person to sign the terms of reference, because it was done in the course of arbitration. It's different from just arbitration agreement. When parties are entering the contract, the person have no authority to sign the contract. It's a separate issue. And the other the challenge issue, again, it appears to me that Vietnam is quite oftenly argue that whether the person is authorized to sign, and I see that it is the same in some Gulf countries. Some countries are very strict in whether the person is authorized to sign, and the Gulf countries, they are very much pay attention to the power of attorney, so particular documents, the power of attorney. But most jurisdictions, as you know, the power of attorney is not a big issue. So as long as the person is properly authorized, and then there is a parent authority theory also applied. So in many cases, the parties just sign, any person involved in the transaction sign the contract will be treated as the valid contract. Same apply to the arbitration agreements. And arbitration agreements can be executed by just exchange of the email or some other form of the writing document without signature. So the signature part is again, if it's required under the local law, of course it will be issued. But the most jurisdictions don't necessarily require the signature of the agreement, as long as we can evidence arbitration agreements by documents. There'll be the valid arbitration agreement. So there is general tendency, and when you're involved in the actual case and in international arbitration, the tribunal have very strong tendency to extend their jurisdiction. Although maybe at the end of the day, such a word may be challenged in the local court, but normally tribunal try to confirm with the claimant whether they're happy with their case. The tribunal, meaning that, okay, tribunal will lend the word at the meeting the arbitration agreement. Then if you try to enforce it, you might have a challenge in that particular jurisdiction. Claimants maybe want to avoid the situation. They want to make the case more concrete, or they may want to pursue that possibility. So tribunal just give the warning to the claimant, just say, it's quite possible that that challenge will be made in the enforcement procedure. You still want to, proceed arbitration based upon your arguments that the arbitration is valid. But if the claimants want that, and the arbitration agreement is signed by a person who seems like have a authority, or given all the circumstances that the arbitration agreement is properly executed by the parties, I would say that generally speaking, I should not generalize too much, but there is some case where the arbitral tribunal will deny arbitration agreements. But most likely, when they have, as long as a person who involved in or in charge of the matter signed the contract arbitration agreement, then they'll be treated as a valid arbitration agreement. I hope I can answer your question properly.
Yes, of course. Because we now go to third of the event, we want to move to the Q&A questions because we received lots of questions from our participants. And the first question maybe addressed to Mr. Kim is, could you share the cases where there is explicit ground to challenge the tribunal's jurisdiction, but a party should not raise the jurisdictional challenge? To clarify, the question is, we have the explicit ground to challenge the jurisdiction, but whether the party should not raise the any circumstances that such party should not raise the jurisdictional challenge, even though we have an explicit ground to challenge.
Oh, okay. So if there's agreement says that you shall not allow the challenge in any event, if a party agreed to the in a contract that contains that prohibit the party challenge arbitral agreement, that's what you said.
Yeah. So I think that there's some cases where it related to the constitution of the arbitral tribunal, for example. But one of the parties decided to not raise the jurisdictional challenge. So any reason, upon your opinion, any reason for them to not raise the jurisdictional challenge?
I think the audience want to hear your personal experience, Kevin. Is there any case you already recommend your client not to raise jurisdictional challenge?
Oh, okay. Yes, yes. You know what? If there is a some case where actually that there's some issue of arbitration agreement, but uh, uh, but we may have concern that there's no arbitration agreement, then it's go to the code, local code, and then you have a concern about what happens in the local code, and then we might have issue that you know you know, if you have a wonderful tribunal, very experienced, and we think that it's better to have arbitral word rather than the court decision. And there's some issue where there's quite complicated technical issue, or some very complicated financial transaction. Then we expect that probably you have difficulty to explain to the court, and the judge is kind of gambling what will happen in a court. Then we just say, you don't have to necessarily to challenge the word. Maybe you can just agree to arbitrate. There is some possibility, and then we have some occasion where we recommend the party to agree. But I have two occasions where we file arbitration, knowing that we have problem in arbitration agreement, but we expect that the other party would agree to the arbitrate. And then they did. They say that, oh, we have no arbitration agreement. However, we agree that we just arbitrate. You arbitrate, we agree. We have no objection. So that may happen. Yes.
Yes, thank you. Ms. Han, do you have any experience related to such matter? Maybe you could share with us.
I will share the same view that in some cases, we would advise the client, in case it is, it depends on the position of the client, but in some case, we may advise the client not to challenge the jurisdiction, because if the jurisdictional challenge success, and then the case would be brought to the court, especially the Vietnamese court, and it would not be beneficial for our client to have a case to be heard in the local court, especially when they are foreign companies. The litigation in Vietnam would be, there are some many problems with the litigation in Vietnam, and in such a case, we may advise the client to not to raise the jurisdictional challenge, especially if they also have a counterclaim. Sometimes if the jurisdictional challenge relates to when the matter of jurisdiction and substantive issues very has close link, and it cannot be easily separated. So we also consider not to raise the jurisdictional challenge.
Yes, thank you. The next question from our participant is related to a specific case. So I will just brief it for your understanding. In the case, in such case, we have two contracts. One is the MOU and the other is an official contract. In the MOU, parties agree, parties have already have an arbitration agreement which go to SIC. And in the official contract, we have another arbitration agreement which goes to VIC in Vietnam. And the details of the arbitration agreements in these two documents are not compatible. So the question we have here is, which one will prevail, and whether based on the severability of the arbitration agreement, both the two arbitration agreement is valid or not? And in case it's valid, then whether one parties could go to SIAC and the second parties could go to VIC or not. Yes.
Okay, so quite interesting situation. But you know, okay, first of all, if there is the same parties in same transaction, if the two arbitration agreement, then the arbitration agreements entered into by the parties, most recent one should be valid. So the previous arbitration agreement was the maybe changed, amended to the arbitration agreement. But in this case, the first document is MOU. So MOU normally we understand that it's non-binding agreement. I don't know whether that particular situation that the MOU is binding or non-binding, but the MOU was non-binding agreements and more like preliminary the arrangement of the parties, while the definite agreements is more accurate deflection of what parties finally agreed upon. So I would say that the arbitration agreements in the definite agreement should prevail. However, if dispute is about MOU, not about the agreement, it's difficult to think about it, but you know, if there is something about the MOU, maybe you can say you can pursue the arbitration, and that the previous arbitration rules, if there is a really only related to the MOU. But I think that part is relatively clear. But I have a very interesting case where there is a NDA, a non-disclosure agreement. So a pharmaceutical company approached by other pharmaceutical company and say that we are going to share some of our technology. So you guys signed an NDA. NDA contains arbitration agreement, and party negotiate for 2 years. They failed enter into a final agreement. So there's no agreement. Then the one party file arbitration based upon the arbitration agreement in the NDA. And the other party say, oh, you know, NDA is about the disclosure of the documents. It's not about the relationship of this contract, and no contract yet. So there's no arbitration agreement. But that case is ICC arbitration in Paris. I noted that under French law, and that there is a French court decision. They say once parties enter into a arbitration agreement, and unless the parties agree the different arbitration agreement or the waive or just to give up the arbitration agreements at the later stage, any dispute in connection with that dispute, that transaction should be arbitrated the same arbitration. I think it's a bit too much. I think, you know, most jurisdictions will deny the arbitration, the jurisdiction of arbitration, arbitral tribunal, because NDA is quite clear that it's limited to the disclosure of documents, not about transaction itself. But there is some jurisdiction where they expand the arbitration agreements, even if it is not really covered that the definite agreement. So if you have situation where if there's MOU, have arbitration agreement, and then the definite agreement does not have arbitration agreement, right? Then one party just want to file arbitration agreement, the arbitration based upon the arbitration clause in MOU. Then you have an interesting question, whether that arbitration agreement can extend to the definite agreement or not. If the definite agreement has the clause, any dispute resolution clause, that will prevail definitely. But if there's no dispute resolution clause, no jurisdiction, no arbitration clause in the indefinite agreement, then you have an interesting question whether MOU, arbitration agreement MOU, will cover or apply to the dispute in a contract following the MOU. But again, I'm just saying, many jurisdictions will deny because the MOU and definite agreement are separate. But there is some jurisdiction or some tribunal may extend the scope of arbitration much broader than you expect.
Yes, actually, the case that the case in question is related to an M&A transaction. So it's an MOU, and the official contract is the share purchase agreement. So maybe the two documents have different functions, and the dispute under the MOU might be different from the dispute under the SPA. So yes, that's what you mentioned before, that in such case, we may have some conflicts between the arbitration agreement, and one parties may go to the arbitration agreement under the MOU when it's come to the dispute in such document. How about in Vietnam, if such case happen? Because we know that in the SPA, the arbitration agreement refer to the VIC. In such case, what will the court consider, or maybe the arbitral tribunal at VIC will consider this situation? Ms. Hân or Ms. Ha, can you share with us?
Actually, I agree with Trang that the MOU and the SPA in the M&A deals may serve different functions, and then it would depends on which claims the claimant would raise, and then so whether it would fall within the scope of the jurisdiction under the MOU, or would it fall within the scope of the SPA, it would depend on the case. It would much depends on how exactly the arbitration clause, the wordings of the arbitration clause, and the exact forms of and the contents of the MOU and the SPA, and then it would be difficult to give an concise answers on for this question, because in order to decide which arbitration clause would be applied, we need to review actually the documents and the claims of the claimant.
Yes, on this matter, I also agree with the opinion of Ms. Ha. To identify with the arbitration constitution have the jurisdiction to resolve the dispute, it should depend on the merit of the case, and whether the parties have the dispute covering by the MOA or the SPA. MOA or the SPA, and if the arbitral tribunal identify their jurisdictional, and then the word was brought to the local court for consideration under the set aside procedure. Within that, the court will also cross-check whether the dispute arising from which document, MOA or the SPA, and the parties in such a dispute whether have signed an arbitration agreement together. Yeah.
Yes, thank you. The next question also, I think that is also related to the scope of the arbitration agreement. So the question is, if the insurance company disclaims liability to the insured, the liability dispute must firstly be settled by the national court as the precedent precondition to the arbitration. And the tribunal only had jurisdiction regarding the dispute or difference as to the quantum to be paid under the insurance policy. So in short, parties agree that for the liability dispute, parties have to go to the national court first, and the arbitral tribunal only have jurisdiction to consider the quantum to be paid under the insurance policy. The question here is, what do you think about this type of arbitration agreement? Is it a tactic used by the insurance company to cause delay? Yes, very interesting question. Mr. Kim, maybe you could share your view with us.
Not necessarily, because I mean, I don't know what type of industry it covers, but the insurance, calculating the damages of the insurance claim is more like technical, depending upon the certain industry. Maybe you feel more comfortable to have arbitration in calculating damages. Particularly in case of arbitration, you can bring in your own expert. But in case of the court practice, court appoint appraiser, and the appraiser just to make a the recommendation the court accepted, then we have no control. But as whether or not you are liable, the insurance company is liable to pay to the insured, that's a legal issue. So the maybe the parties want to litigate to decide whether or not the insured have insurance company have obligation to pay, but as the calculation of damages or insurance amount, it's more like a technical issue. And then particularly when you have deductible, you have some quite complicated calculation issue, then you might have, you want some expert on the experience in insurance market. For example, in the reinsurance industry, which is quite unique, and the typical arbitration clause in the reinsurance industry is that there's two arbitrators. So each party appoint one arbitrator, and two arbitrators arbitrate. And then when two arbitrators fail to agree, then they call umpire. So which is quite typical, which is actually the default the way in the UK arbitration law. UK arbitration law have each party appoint one arbitrator, and then the umpire come in. You'll be very surprised. Most cases in the reinsurance arbitration, two arbitrators agree. Because this industry is very small, you'll be totally embarrassed if you cannot agree and third arbitrator came in and you're wrong, that is quite embarrassing. Because this is a special, very special industry. I have experience in Korea. I have a similar situation, similar clause. So we have two arbitrators, and we appoint one, two professor, very well-known professor. But we did. I wouldn't expect that we'll have agreed word by two arbitrators, but surprisingly, they agreed because they are so respected professor. They really worry about they don't want lose their face in front of a third arbitrator, just say you're wrong. So it's a very reasonable decision made by the two arbitrators. So in the insurance industry is very unique. So I think it's not a bad idea. You want to proceed the litigation first on the liability and decide on the quantum. But I must admit that I never seen such a dispute resolution clause. And if somebody want to delay, it's quite possible that you want to delay a lot, right? It's much better to decide everything in a court or in arbitration.
Thank you, Kevin. I agree that I'm not so sure if that dispute resolution clause is workable in Vietnam, because simply think that we cannot limit the national court power to hear the case and to make the final judgment. We cannot say to the court that we just want you to decide on the liability issue. The quantum of the damage, we will leave it to the arbitration later. I don't think the national court will accept it. I know it's very late now, but you just finished your term as the Vice President of IAC Court, and I know that you are also the chair of the KCB International Committee. I am also on the panel of the KCB International. So I think we should talk a little bit to promote KCB here for the local audience. My question to you is there any difference in considering the jurisdictional challenge in KCB International Arbitration and the ICC arbitration?
Oh yeah, that part is quite different. Jurisdiction itself, the arbitral tribunal decide is same. But if there comes to the challenge to the arbitrators, there's a huge difference. ICC arbitration, as you know, we have a ICC court, and the court system and the court members, as court members get together and decide on that issue. While in the KCAB, we don't have court, and KCAB chairman will make decision on the challenge. So when the KCAB chairman decide on challenge, KCAB chairman will listen the recommendations from the International Arbitration Committee. So that's quite similar but quite different. Of course, that we will hear from the tribunals the view on the point. Some jurisdiction, some arbitral institution, the tribunal decide on the challenge as well. But in many jurisdictions, many institutions actually they have their own system to decide on the challenge, and the on different challenges in the course of appointment or nominating arbitrator. Again, the party challenge, then the institution will decide. Again, KCAB, the chairman will decide with the recommendation of International Committee, but ICC court decides. So it is quite different.
Yeah, regarding the question of Ms. Trang, I have just raised about there are two arbitration agreement in the insurance contract. I would like to share. We have handled some insurance case, and in some case we have also see some arbitration clause like that. There are a clause choosing the court, local court, and another clause choosing to bring the case to the arbitration. And from our view, we think that may come from the because the local insurer have reinsure the contract to the foreign insurer for such case, and they have input the standard term and condition of the foreign insurer in the insurance contract with their local insurer. But in Vietnam, I think it's not practical, because if there is a dispute happen and one party bring the case to the arbitration to decide on the quantum of the insurance, I think there will be a risk that such a word may be set aside by the local court, because there is a clause referring the dispute to the local court to identify the liability of the party, and we can see that the liability of the party in the insurance contract may also conclude involve the quantum of the insurance. So it's disputable, and there will be a high risk for the party, for the award to be set aside by the local court when a dispute happens from such insurance contract. Yeah.
Yep. Thank you, Ms. Han, Mr. Kim, and Ms. Ha for sharing all your experience and knowledge with us today. Now it's 5:30, and we still have nearly 100 participants staying with us now. In fact, we have received more than 150 registrations, but due to the limited slot, we could not accept all. And I also realized that a lot of registers are comments on our Facebook and network and asking why we cannot accept them. And I'm so sorry for that. I also noted that we still have some questions which have not been answered by our panelists. Then please send your question to us by email, and we will forward it to the panelists for their consideration. Still, thank you very much for your time. We hope that you enjoy our first topic. And at the end of the day, we will share a short reading list and the slide which was kindly prepared and recommended by Mr. Kim on this topic. I also would like to introduce that our next webinar will be conducted on next Friday, 24th September, and it's based on it's related one of the most interesting topic, which is how to face pitfalls in arbitral proceedings, or how to prevent the guerrilla tactics from your opposing party in arbitration. In our second webinar, we will have Mr. Mike McCrew, the partner and head of zone office of Herbert Smith Free Hills. He will share his experience in this matter, and we look forward to seeing you on 24th September, and have a nice weekend.
Thank you, Kevin.
Yeah.
Thank you very much. Thank you.
Thank you,
Bye.
Kevin.
Thank you. Goodbye.
Bye.
Yeah. Bye.